He can't be elected president again. The 22nd Amendment is clear about that. He also can't be elected vice president. The 12th Amendment is clear about that.
The amendment we have says no person shall be elected to the office of president more than twice. Well, there are other ways in which a person becomes president. A person could be named in a succession statute. A person could be a vice president. A person might be chosen by the House of Representatives. Regardless of what one thinks about Mr. Trump, about President Trump, it's a good idea to have a clear-eyed perspective on what the law actually is.
The 22nd Amendment is something that has been discussed at length, right? The idea that, no person shall be elected to the office of the president more than twice. But it does seem that some believe that there are ways to get around that. So let's talk to two people with, slightly different. This isn't a debate. This is just a nuanced discussion among two experts who know this. David Super, professor of law at Georgetown Law, and Bruce Peabody, professor of government and politics at Farley Dickinson University in Madison, New Jersey. Thank you both for coming on the program. Appreciate it. Our Professor Super, let me start with you. Is there a workaround here for President Trump that could work if it made its way through the courts?
He can't be elected president again. The 22nd Amendment is clear about that. He also can't be elected vice president. The 12th Amendment is clear about that. So the most he could try to do would be have two dummy candidates run for president and vice president and try to insert himself somewhere farther down the line of succession and have the two dummy candidates resign.
But talk to us about the 12th Amendment. When you said he can't run for vice president because of the 12th Amendment. Explain that to us.
The 12th Amendment says that no one may run for vice president who is constitutionally ineligible to serve as president. So he would be constitutionally ineligible to serve as president because he'd already had his two terms. Therefore, he could not serve as vice president.
Now, President Trump has suggested that he will not run for vice president to serve a third term. This is number 3. This is at that same gaggle that happened a couple days ago. Let's listen.
One theory on how you might try to serve a third term is that you could run as the vice president.
Yeah, I'd be allowed to do that.
Is it the White House's or the White House counsel's or your legal position, I guess?
You'd be allowed to do that, but I wouldn't do that. I think it's too cute. Yeah, I would rule that out because it's too cute. I think the people wouldn't like that. It's too cute. It wouldn't be right.
All right. So whether he sticks with that or not, Professor Peabody, you think that there is a legal route for him. Tell us why.
I do. So I think it's significant that the language of the 22nd Amendment is the language of the 22nd Amendment, right? We might prefer a more comprehensive, a more careful set of measures, but that's not the amendment we have. The amendment we have says no person shall be elected to the office of president more than twice. And as we know, there are other ways in which a person becomes president. A person could be named in a succession statute. A person could be a vice president. A person might be chosen by the House of Representatives. So again, there's reasons why the language of the 22nd Amendment is what it is, but it is not comprehensive. It is language that opens the door to some of these other scenarios. And regardless of what one thinks about Mr. Trump, about President Trump, it's a good idea to have a clear-eyed perspective on what the law actually is.
And so you've laid out, 1, 2, 3, 4, 5, 6 ways, right, that you think it is possible he could be elected as vice president and become president through the new president resigning, et cetera, being elected as vice president and then becoming acting president under the 25th Amendment, being elected as vice president and then becoming president if the president-elect dies before taking office, being elected as vice president and then becoming acting president if no president is chosen before their term begins, being Speaker of the House or another position, and becoming president if the president or vice president both die or resign. So this is going to require a strategy, right? And the final one is being chosen by the House of Representatives to serve as president if no candidate receives a majority of electoral votes. But this would be something where if he's telling the truth, right, that he won't run as vice president in 28, is there any other option as far as you're concerned?
So, I mean, I think all the scenarios identified in that earlier scholarship remain valid, remain viable. If we take the president's words in late October 2025 as invariant and written in stone, and he'll never change his mind, a set of assumptions that I'm not sure we should be making. But even if we were to set aside the different scenarios that involve him being vice president, I don't think it's off one's rocker to say, well, might he change his mind if Congress were to change the succession statute to either with an eye on a twice elected president serving in the line of succession, or perhaps putting him in some special constitutional officer role. So again, whatever you think of the merits or demerits of Mr. Trump, it is I think, arguable oddity that our presidential succession sort of lineage, or our line of presidential succession, puts the Senate pro tem in fourth in line, right? So whatever else we know about the president pro tem, the kind of nominal president of the Senate, setting aside the vice president, is that person is a creature of the Senate, right? They are distinguished by being in the Senate longer than anybody else. So almost by definition, that person is going to know a lot about the Senate, but probably not a lot about the executive branch. And that's exactly the kind of experience you might want if there were a crisis that knocked out the president, vice president, and the Speaker of the House. So that's just a different way of saying it might not be a bad idea for the nation as a kind of policy matter to consider having twice elected presidents in the line of succession.
And policy is a slightly separate question here. And Professor Super, though, it is, if Donald Trump decides he wants to run again, there is no doubt that he will pursue every possible legal argument. And I think that if in the end he decided he wanted to do it, and the only way was via running as vice president, I think he would do it. But is your position, despite the efforts that Donald Trump would make, that the courts would come down definitively against him in any of these efforts?
Obviously, I don't know. Predicting what the courts will do is difficult. The Supreme Court concluded that only Congress could enforce the insurrection clause, which makes someone ineligible to serve in any government office if they have participated in an insurrection against the United States. It's certainly possible the court would decline to enforce the 22nd Amendment and regard that as a political question. I would not be surprised if some justices were disposed to do that. It would shock me if a majority of the Supreme Court was.
Do you disagree? Do you disagree with that, Professor Peabody?
Well, I don't disagree that it's a hazard to try to predict what the Supreme Court will do. But I will say, I think there's three factors that sort of push in a little bit of a different direction. One is the overall sympathy that a number of justices, I think arguably a majority, have for this sort of general notion of the unitary executive. While that's a slightly different set of arguments than those we're talking about today, they're certainly consistent with the idea that we ought to look to powerful, so supposedly unified leadership from the one branch, and that the structure of the executive branch allows for sort of extraordinary powers. Second, this is a court that's very open to what's sometimes called textualism, right? They really put the rubber meets the road for the court, supposedly, where they are taking rather straightforward, rather rigid, rather narrow readings of what the letters of the Constitution say. And here what those letters say is that the restrictions of the 22nd Amendment really bar presidential elections. And I guess the third point is just one that you already mentioned, Dan, which is this is not a president or an administration that sort of reads the law in kind of settled or
Well,
common sense, or everybody knows this is what the law means. They are more than happy to be iconoclastic, and this reading certainly would be
but
iconoclastic.
when you say that they're textualists, what ambiguity? I mean, I understand no person shall be elected to the office of the president more than twice. You know, if you want to say you're a textualist, it's tough to read that in any other way. Then you can't be elected more than twice, right?
You certainly can't be elected to the office of president more than twice, but you could be elected vice president.
Yeah.
You could assume the office through non-electoral means. And I mean, part of the pause here is that the Congress, especially the Senate, that was considering language to address these issues, to kind of provide a response to the unprecedented four terms of Franklin D. Roosevelt's presidency, they considered earlier language in the debates that clearly would have foreclosed the kinds of things we're talking about today. And they ultimately dropped those earlier drafts, dropped the more comprehensive language that talked about controlling people who had served or during all or portions of a prior term. They dropped all that and went with this different language about elections. So everybody knows what the 22nd Amendment means, except when you actually read it and you consider it vis-a-vis the other provisions, it's a bit less comprehensive than I think most folks assume.
But Professor Super, again, you disagree when you, in particular, when you view it in the context of the 12th Amendment as well, right?
I do, and I would note that Professor Peabody is completely correct that this court is very textualist, and the very kind of argument he made about earlier drafts in legislative history is precisely what they say they don't like to consider. So they would look at the text that we have here. And I think pretty clearly someone who is under 35 years of age could not be vice president under the 12th Amendment because they're not constitutionally qualified to be president. And I believe that the 22nd Amendment pretty clearly means the same thing. I would also note that this Supreme Court, while it talks a great deal about textualists and mostly walks the walk, is also very conscious of the separation of powers and the balance of powers, and has been willing to go off text to enforce that. Most obviously, when they declared the president was immune from criminal prosecution, nothing in the Constitution says that. There is something about Congress, there's nothing about the president, and the Supreme Court decided that having presidents prosecuted for things they did as president is inconsistent with the purposes of our constitutional order, and struck that down without any textual support. I think a crude effort to evade the obvious meaning of the 22nd Amendment would run into similar problems.
We're going to take your calls at 866-967-6887 in a moment. And, you know, it does seem that just about everyone outside of Steve Bannon and the president himself recognize that there really isn't a road here for President Trump to run again. This is Speaker Johnson. This is, I think this is from yesterday or today, number 4.
Because under President Trump, the Republican Party has delivered. I mean, you're talking about reducing taxes, reducing regulations, cutting fraud, waste, and abuse, ended the border crisis, ending the crime crisis, resolving conflicts, wars around the globe, and working on these amazing trade agreements. It's been a great run. But I think the president knows, and he and I have talked about the constrictions of the Constitution, as much as so many of the American people lament that. The Trump 2028 cap is one of the most popular that's ever been produced, and he has a good time with that, trolling the Democrats whose hair is on fire about the very prospect.
There you have the speaker indicating that he thinks that Trump is just trolling Democrats. But we've seen many times what initially seemed like a long shot suddenly ends up becoming much more of a reality. But look, we've got two professors who are experts in this area with slightly different points of view. I mean, I think they both agree on what the Constitution and the law says. They I think they disagree a bit about is there wiggle room within that.